in company law. Then SEBI has brought out an ICDR, and then issue comes for the reclassification. Now, reclassification, previously it was very simple point, but after some time, when the reclassification issue came, and the law has also taken place, and law is telling that if there is a violation by any promoter, then his account will be freeze. If he is doing something wrong, he will be the culprit. He cannot bring out capital. He cannot bring out access the capital market. So various new aspects has come. And earlier the system was simple. It was through board process. You can change the change the promoter. But after some time, when there are so many companies where promoter were not doing the compliances, promoter were not following the law, and the stock exchange was suspending company, and then they were freezing their demat account, then this issue of reclassification has surfaced in a different aspects. So today we will go ahead with and ask each and every aspect which is possible, and I'll request all the delegates that you have any query, you can raise here. We will ask from the learned speakers and the speakers from the stock exchanges, and we will try to solve your queries. So now I will request Anjali that she start with this. But before this, because I have seen in the last, I will announce in the last also, we are doing webinar on every Friday. And I was always normally announcing at the last, but so many people in between they go. So that's why I'm informing everybody. Next webinar is very interesting. And that is we are doing with SEBI, freezing of PAN number of this designated person under PIT regulation. Now, SEBI has mentioned this, that if there is a designated person and designated person cannot trade during the various window closing time and various other information or very other price sensitive information, if they possess, they can't trade. So SEBI has proposed that freezing of their PAN number, though it is looking very easy and very good for the compliance officer point of view, because he has to track everybody's accounts and then instruct and doing this. Now automatically, as soon as a some corporate action and other information is there, so they will freeze the PAN number. So automatically these designated person cannot trade. It is looking good, but it has so many other issues also. So in next webinar, we will discuss this issue, and the speakers from Stock Exchange, SEBI, and the depository, all three institutions, they will be there, and we will discuss in detail each and every aspects on this. And Mr. Sundareshan will be the chief guest for this program. This is the information. Now over to you, Anjali, and please tell us the reclassification of promoter group. What is the concept of promoter group? How it is happening? What are the issues coming? What was the law? How it has taken shape? And what are the queries you have? Over to you, Anjali.
Thank you so much, sir. Good afternoon, friends. Reclassification is a very, very interesting topic. This is our second webinar on the reclassification. One may feel that reclassification is not that big a topic wherein 2 webinars would be required, but then we were receiving so many queries ever since our last webinar and ever since the promulgation of LODR, I should say, that with regard to reclassification, how to proceed. And when we talk about reclassification, it's not, as Pawan sir said, it's not a simple thing, because it involves many sensitive and touchy topics, because the people whom you are trying to reclassify or who are seeking reclassification are your own relatives and friends. So one needs to be not just in compliance with the law, but also there are issues which are needed to be looked into. Charu? Yeah, so reclassification, as the word itself suggests, wherein in a situation, a person belonging to the promoter or promoter group wanting to change his status from promoter to public, or even vice versa, wherein somebody is shown in the public category and how he or she can be brought within the promoter's ambit. The entire concept of reclassification revolves around basically three set of people: promoter, promoter group, and people belonging to the public category. Now, why the reclassification need has arisen? Prior to LODR regulations, prior to 2015, there was nothing called reclassification. But why this need has arisen over the years? Because first of all, even the definition of the term promoter and promoter group has changed over the years. Initially, in the erstwhile DIP guidelines, there was no definition of promoter. It was borrowed from the definition as given in the takeover regulations, and takeover regulations had a different connotation for the word promoter or promoter group. Slowly, when we moved on to the to the ICDR regulations, the connotation changed, and we'll be taking up the definition in the coming slides. There can be a situation wherein I incorporated a company, say 1940s or 50s, with a friend or a partner. Now those people may be there, may not be there, and their children have stepped into the shoes of the promoters, and they may get along, may not get along, and they do not want to remain in the promoter's relationship with the other person. Then married children. My daughter or my sister is married into a different family. It can be even be a competitive family, competitive business. Then I do not want them to remain in my promoter group. Then family disputes or legal separations. Some of the person has passed away pursuant to their will, divorce. All these cases are some of the examples which gave rise to the law, wherein reclassification was needed, and why people started to feel that we need to be reclassified from one category to the other. Now, the definition of the term promoter. As I said, promoter definition has undergone sea changes over the years. So the present day definition of the promoter is any person who's named in the offer document, that is the prospectus of the company, or if the company gets into direct listing, or any of the offer documents are filed, information memorandum are filed, anybody who's named as a promoter therein, or in the annual report of the company. In the initial days, when the definition was there only in the takeover regulations, it was only mentioned offer document. The annual report was not there. So meaning thereby annual report, if in the offer document ABC was shown as the promoter, but in the annual reports you're not showing him as the promoter, so as per the present ICDR regulations, that person may be out of the definition or out of the purview of promoter. Then any person who controls the company directly or indirectly. Now, directly or indirectly are very, very wide terms. I am not holding even a single share in the company. I was not there in the offer document or annual report of the company, but the company is running as per my directions. I give the directions to the board. Then the person would be falling within the ambit of promoter, or any person who advises or gives directions to the company or instructions to the company's board would also fall within the ambit of a promoter. The term promoter is also defined in the Companies Act 2013. 1956 Act did not define the term promoter, but 2013 Act defines the term promoter. But for a listed entity, the ICDR definition is the main definition, that will be the governing definition. So herein again, a person named as in the prospectus or in the annual returns of the company, of anybody who's named as the promoter, anybody who controls, herein again directly or indirectly has been used, and anybody who advises or gives directions to the company's boards would fall within the ambit of a promoter. Promoter group is a very, very wide definition. You can see the same from the contents of this slide as well. Promoter group includes promoter and his or her immediate relatives. Immediate relatives cannot be said that they are not that they are not forming part of the promoter group. They are the promoter group. Then it further differentiates that in case the promoter is a body corporate, so any holding company of the same or any subsidiary company of the same would be the promoter group of the company. Any body corporate in which such promoter holds more than 20% of the capital, or wherein a group of people or the above mentioned people hold more than 20% would also be falling within the ambit of promoter group. And where the promoter is an individual, so any body corporate or corporate company or HUF or firm wherein the person or his immediate relative holds more than 20% would fall within the ambit of a promoter group. And likewise, any body corporate in which the above mentioned people hold more than 20%. In this category, there is another head added, any person shown as promoter group in the shareholding pattern. So anybody whom the company is showing as the promoter group in the shareholding pattern would automatically be coming within the definition of promoter group. So one can very easily, assimilate that why this reclassification requirement must have arisen over the years, as to so many people are falling within the ambit of promoter and promoter group. There may arise situations wherein people part ways, people want to part ways, and thus the reclassification. Now, who is a non-promoter? Anybody who's not falling within the above two categories of promoter or promoter group is a non-promoter. I'm being shown as a promoter or a promoter group. Yeah, problem kya hai? No, there are obligations attached to somebody who's called a promoter or a promoter group. There is a concept called once a promoter, always a promoter. Agar main ek baar promoter add ho gaya aur mujhe reclassify nahi kiya gaya, so would that mean that I continue to remain as the promoter of the company throughout my life, throughout the company's life? In case the company gets suspended, company is non-compliant, company has not paid the SOP fines, and the company gets suspended, the demat accounts of the promoters as well as the promoter group are frozen. Then the company or the real promoters of the company do something wrong, then also the other promoters or promoter group get affected. If the company is compulsorily delisted, all the promoters, promoter group, companies promoted by them, they are all ineligible for a period of 10 years from accessing the capital markets, and demat accounts of the promoter as well as the promoter group get frozen. So these are severe repercussions, severe obligations of a person belonging to the promoter or promoter group. Some of the procedural requirements: once you are in the promoter or promoter group, you have to make extensive disclosures under the takeover regulations as well as the insider trading regulations. By virtue of being a promoter or promoter group, you automatically fall within the ambit of a designated person as given in the insider trading regulations. Then, if you're wanting to raise, and if the company is wanting to raise any funds by way of preferential issue or rights issue, there are additional restrictions which are there on people falling within the ambit of promoter and promoter group. So if somebody is not suiting within that category, it's better to move out of it, of course, within the parameters of the law. Now, these were all the obligations. I continue to remain a promoter or promoter group of the company. Then what can be the implications or impact on me? So there are two SOP circulars by the SEBI. One is of 2018 and the other is of 2020. As per the 2018 circular, if a company does not comply, does not pay with the SOP fines, the demat accounts of the promoters as well as the promoter group can be frozen. However, by the time 2020 circular came in, SEBI realized that it may not be the promoter group entities or promoter group who have done any of the non-compliances, or who are, because promoter group may not be directly involved in the decision making of the company. So by 2020 SOP circular, SEBI gave a relief that only the demat accounts of the promoters will be frozen and not the promoter group. So this is also again very important, so that at least from promoter to promoter group categorization or classification should be very correct in the shareholding pattern of the company. So journey of reclassification law, as sir also said, and I said in the initial, prior to 2015, there wasn't anything called reclassification in neither in the erstwhile listing agreement nor in any of the provisions. So the reclassification process is very, very simple. Prior to that, companies used to pass a board resolution wherein they used to pass a resolution that XYZ is being reclassified from promoter to public category. And from next shareholding pattern onwards, the person's name was not appearing in the shareholding pattern. But in the year 2014, SEBI came out with a discussion paper, consultation paper, wherein it envisaged certain situations which may require a reclassification. And they also coined the phrase, once a promoter, always a promoter, may not be a true situation, statement in every case. There may be cases wherein a reclassification may be warranted. So when when LODR was promulgated, it had the regulation 31A within it, which talks about reclassification. In the year 2018, SEBI again came out with a consultation paper, which included the Kotak committee recommendations, and it paved it to streamline the process that the company is required to follow while processing a reclassification request. Then amendments were made, according amendments were made in the listing regulations. Another consultation paper was made in 2020, which further streamlined the process as was existing, and the present law 31A as exists is there. So a basic question many a times may arise: what was the need of putting in this provision, bringing in this provision in the very first place? So SEBI observed that although we are saying that prior to a promulgation of 31A or promulgation of LODR, board used to pass a resolution. But in many of the cases, there was no board resolutions. There were no minutization of the persons being reclassified in the board minutes. And even there were no disclosures being filed with the exchanges. So there had to be a proper streamlined way of reclassifying a person from the promoter to the public category. That is where this provision or this law came in. Yeah. So some of the situations which may call for a compulsive reclassification, as sir also said in the beginning, there may be disgruntled promoters, though promoters who are not in talking terms to each other. They can be friends, they can be relatives, or we are seeing many of the cases wherein children are not connected or not interested in the parents listed companies. So they want to be reclassified. They do not want to be a part of their parents listed companies. So these are the situations which warrant a reclassification to happen. Then there can be amicable reclassification situations wherein takeover open offer has happened, or pursuant to a scheme of arrangement it's there, or pursuant to IBC order is there. So these are amicable situations wherein generally any of the issues are not involved. Now the present law, the famous 31A, which is there. Now, what is the present law? Who all are allowed to be reclassified? Who all are not allowed to be reclassified? I'll ask Charu to take over and explain the provisions. Charu, over to you.
Thank you so much, ma'am. Taking forward, I'll describe the law provisions of Regulation 31A, which are there at present. So Regulation 31A defines a promoter who is seeking reclassification, in which it says the promoter or a person belonging to the promoter group, which are seeking reclassification of status as public. They are defined as a promoter seeking reclassification. In addition to the same, they have defined the persons which are related to the promoter seeking reclassification, which includes their immediate relatives. In case the promoter seeking reclassification is a body corporate, its subsidiaries and holding companies, and the body corporate in which promoter holds 20% or vice versa. In another case where the promoter seeking reclassification is an individual, then in that case where the body corporates where promoters or its relatives or their firms or HUFs own 20%, or where this body corporate owns 20% or more, that are also regarded as persons related to the promoter seeking reclassification. In another situation where HUF and firms where promoters and their relatives own 20% or more, they are also regarded as persons which are related to the promoter seeking reclassification. So herein we have discussed who are the persons which can seek reclassification. Moving forward, the persons who cannot be reclassified under the extant law. So as per the provisions, the outgoing promoter and the persons related to him, her, or in case of a body corporate, if together they hold more than 10% of the voting rights, they exercise control over the listed entity either directly or indirectly. They have some special rights pursuant to an arrangement or an agreement. They are acting as the director of the listed entity, or are acting as in the capacity of a KMP in the company, or they are any of them is a willful defaulter or a fugitive economic offender, then these persons cannot be reclassified. Moving ahead, what are the conditions which are prescribed under the law for reclassification? What a promoter going to be reclassified or is he's intending to be reclassified has to meet the conditions. So in that case, the outgoing promoter and persons related to him shall hold less than 10% in the company. They should not have any control over the listed entity, should not have any special rights. They shall not be in any position, be in a director or a KMP in the company. They should not be in the list of a willful defaulter and should not be a fugitive economic offender. Alternatively, the law also prescribes conditions for the listed entity. So a listed entity can proceed with the reclassification only if they are in compliance with the MPS norms, and there is no suspension of trading at any stock exchange on which they are listed, and there are no outstanding dues to SEBI stock exchange or depositories by the listed entity. Moving forward, the reclassification provisions prescribes a process which has to be followed for reclassification, wherein first a request is being received by the company from promoters seeking reclassification. The company thereafter has to intimate the same to the exchange within 24 hours. Then we proceed for the board approval. Then board approval, the promoter request has to be placed in the next board meeting, immediately next board meeting, or it should be placed within 3 months of receipt of the request. Then shareholders approval has to be taken, and the approval shall be by passing an ordinary resolution, and the time gap between the board meeting and shareholders meeting shall not be exceeding 3 months. Thereafter, the approval of stock exchanges are required. Stock exchange application has to be made within 30 days of the shareholders approval. So here are some categories where shareholders are categorized in the shareholding pattern, either in the public category or in the promoter category. So there might be situations, company might be disclosing them in the promoter group, or they belong to the promoter. There might be a situation they are in the promoter group and they have to be categorized in public. There might be a situation they are categorized in public, or they should be categorized in the promoter group. And the last situation wherein some relative and connected persons are of the promoters are categorized in the public, but they belong to the promoter group of the company. So these was the provisions which have been prescribed under law in the regulation 31. We'll be moving forward with the practical scenarios of reclassification, which would be taken by Anjali ma'am. Over to you, Anjali ma'am.
Thank you, Charu, for taking us through the legal provisions of the reclassification. So friends, as explained by Charu, there are the basic definition, the person who can be reclassified contains the definition of persons related to the promoters. And that is where most of the cases get stuck. And because it covers the persons belonging to immediate relatives category, anybody, any company or person wherein 20% or more is held. So accordingly, we have tried to categorize the scenarios which may arise under the various situations. And these are all real-time cases. These are all live cases which we have found in the practical scenarios. First is reclassification amongst friends. A case wherein company was promoted by two sets of friends, Singh family and Malhotra family. Singh family says a silent promoter. They want to be reclassified. Their collective holding is less than 10%. And they want, the Singhs want to be reclassified. It is comparatively a very, very simplified case. If Singhs and Malhotras are not falling within the ambit of persons related to each other, Singhs will file a reclassification request and they can be, pursuant to the process given in the regulation, they can be reclassified. Now, a case comes wherein it is pursuant to a family settlement, reclassification between family pursuant to a settlement agreement. Two brothers incorporated two listed companies, wherein ABC Limited or LMN Limited. It is decided that A will transfer his entire holding in ABC Limited to B, and B would transfer his entire holding in LMN Limited to A. This is a very, very common scenario, especially in cases of the business houses which had been promoted long back. And to the present, the younger generations may not be interested in carrying on businesses with each other. So in that scenario, one has to check that how A is related with the other promoters or promoter group of ABC Limited, and how B would be related to other promoters of LMN Limited, and then only the reclassification may be proceeded with. There can be another situation in this wherein the family settlement agreement is registered. Via it is not registered. So if it is a registered agreement, the things may be simplified, but if it's an unregistered agreement, then one exchanges may ask for more details as well. Reclassification, again, that is this is an extension of the previous example wherein ABC Limited was promoted by brothers. There is a family settlement agreement wherein one of the brothers, the outgoing brother, has no control over the other person, the company. Then in that scenario, the reclassification situation may arise. Now, reclassification pursuant to a will. Company was promoted by Mr. A. He passed away, and as per the will, he mentioned that his son X would be the inheritor, whereas other two children would not be getting any shares in the company. So pursuant to will, again, is a simplified case. If the will is registered, it's easier. If the will is not registered, exchanges may again ask for certain additional documents to be complied with. Reclassification amongst relatives. Now, married daughter or married sister. The company was promoted by Mr. A and his brother. In the promoter group, their directors or their sisters are there. Directors or sisters are married. They're residing in different houses, and there may be different states as well. And they're holding minuscule shareholding. So In those cases, reclassification may be permitted. Now, reclassification of a sister's company. The company is promoted by Mr. A. Sister's company is also in the promoters category. Sister is not holding any shares in the listed entity. And even that company, private limited company, wherein sister's company, that is also holding very, very minuscule holding in the company. They want amicable settlement without any disputes, without going to any court, without going to the NCLT. So in such a scenario, an agreement is the only solution which may arise, which is there for enabling the reclassification. Now, pursuant to a divorce, 31A permits a case by way of a simplified procedure in case of divorce. A divorced spouse can be reclassified, but a question that arose in one of the cases is that divorced spouse can be reclassified, but then the children of those husband and wife are continuing in the promoter group. That, to my understanding, is a little weird situation because children are common. Children are not divorced. So they will always remain in the promoter group. So this kind of a situation probably regulator may look into. Again, Mr. A promoted a company. E and F are the children. They are the immediate relatives, so they fall within the ambit of promoter group. After his death, E becomes the promoter. F is a promoter of another company, another group company. There is no formal agreement between the two siblings. So in that scenario, what would be the situation? These, in fact, might be the questions that may be addressed by the exchanges as to, in such situations, how the reclassification will be taken forward. Now, certain other cases of reclassification, which we felt are important to discuss at this forum. A company is suspended. The company was promoted by X and his friends or relatives, and these friends or relatives now want to be reclassified. So it's a clear provision that till the time the company is suspended, no reclassification can happen. So the only way is to have the suspension revoked and then apply for reclassification after fulfilling the criteria given in the regulations. Another scenario, which is because still there exists certain set of companies which were referred to by for. So if pursuant to the rehab scheme, there had been a change in the promoters and in the shareholding pattern, old as well as the new promoters are continuing, and old promoters want to be reclassified, who are not connected with the decision making in any way, who are not advising the company in any way. They can be reclassified by following the procedure, provided there is no connect between the old and the new promoters. One of the conditions, as mentioned by Charu, was there should not be any outstanding dues to the exchange or to SEBI. Now, in case there are some SOP fines which have been provided for by any of the exchanges to the company, and the company has applied for a waiver application to them, to the exchange. Now, in that scenario, will the reclassification request be put on hold till the time the waiver application is resolved, or the pending that waiver application, the reclassification can be processed with? Again, there is one of the cases which came across, company was promoted by A, there is nobody in the promoter group, but some of the immediate relatives of A are being shown in the public category. For proper categorization, proper shareholding structure, those people should be shown in the promoters only or the promoter group. So how to bring those persons in the promoter group, definitely within the ambit of promoter group? So for that, we have to see the creeping acquisition limits of 5% as applicable under the takeover regulations. So if the present promoter holding is say 60% and the immediate relative which is appearing in the public category is holding 4.99%, as a result of which it would, in the next shareholding pattern, the increase would be only 64.99. That may be within the permissible limits, but if this immediate relative who's appearing in the public category is holding 6%, as a result of which the increase in the public shareholding, promoter holding would be to the tune of 6% in the next financial year, that would give rise to a question mark under the takeover regulations. There is another unique case wherein the main promoter of the company wants some of the promoters to be reclassified. The main continuing promoter is not on talking terms with the other set of promoters, and he knows that even they will not be giving any confirmation or any request to the company for reclassification. In that scenario, how to proceed with the reclassification? 31A presently says that one has to receive a request from the outgoing promoter. So till the time the outgoing promoter gives a request, this case cannot be proceeded with. Thank you from our side with regard to the regulatory provisions and the practical scenarios which we have faced. Thank you.
Anjali, thank you very much for giving this lucid and detailed presentation on this reclassification. No doubt this topic looks very simple, but when you go to detail, it has multiple interpretation, multiple things. So now I will request Lokesh. So please tell us, because no doubt Bombay Stock Exchange has more companies, more issues of reclassification than the National Stock Exchange. National Stock Exchange has issues which is totally different in nature as compared to Bombay Stock Exchange because of the these so many old companies are not there.
I agree.
Here, and the suspended company also in Bombay Stock Exchange is more than the here in the stock exchange. So what types of cases you are receiving? What is your view on the basis of this presentation which Anjali has given? What message you want to give people how to do it? Because I'm the promoter, or I was the ex-promoter. I want to reclassify it. I have I got married. Now I'm shifting to new house. All these issues are there. So what types of cases NSC is receiving, and how you see all these things? Over to you, Lokesh.
Yeah. Thank you. Thank you, Anjali. I think you have covered everything what is required in the regulations. So there are a couple of points that we have been observing of late. No doubt, reclassification application, we are receiving a lot of reclassification application. Reason being, a lot of promoter and promoter group now realize to reclassify to public. Since they are not involved in the day-to-day business, they are not aware of what happening in the company, and now the liabilities are on promoter and promoter group are higher. That's why a lot of reclassification applications are coming to us. Couple of points which we have been observing. One, since all the listed companies are there in this webinar, so currently what happened that whenever company file a shareholding pattern, so assuming in shareholding pattern there are 10 names of the promoters are there, promoter and promoter group, and next shareholding pattern they file only 8. We have been telling companies that you cannot remove the name from the shareholding pattern until and unless the person has died, or the company had got merged in another company, or maybe they have taken approval. Otherwise, exchange will always ask a query. There will be a discrepancy. So first thing is that while filing a shareholding pattern, company has to make sure whether the promoter group has sold everything. Nil holding is there. Still, he has to mention the name until and unless he taken approval from the exchange. Again, reclassification happen two type of things. One is a board approval, if less than 1%. But what we are observing that there are a couple of companies which misinterpreted the law. Like, for example, A is a promoter of a company and he is a family member, B, C, D. They are family member. If we assuming B want to reclassify, he can apply for reclassification, but regulation said that if its holding is less than 1%, it's not less than 1%. It's talk about he and his relatives. So you have to see overall relatives should hold less than 1%. In case B hold only 1% or less than 1%, then it's okay. But then B and his relatives, A, C, and D are holding more than 1%, then shareholder approval is required. We have been seeing that a couple of cases company missed this law. So that company has to make sure that they should comply with this provision. Second, couple of things are there that there are certain disclosure requirement, which is there again in 24 hours. Receipt of request from promoter, board meeting outcome, exchange filing and exchange approval. There we have been seeing a lot of advisory to companies because we have seen that there are a lot of delay. Filing an application on exchange portal doesn't mean that you have given a disclosure and an announcement. Company has to file a separate announcement because filing an application is a separate module where you are filing. It's not disseminated to the market. It's just an exchange filing. That is a common observation that we are observing. Third is the family separation agreement. What we have seen that promoter group apply for reclassification. Companies do not have any MOU or separation agreement, and sometimes we have been observing that board approve, shareholder approval, and then backdated or maybe after that date shareholder MOUs come. All these things should be before the board promoter apply for declassification. Separation agreement, all affidavit, they should keep well in advance because that is the basic check that exchange are checking. Okay, when the family member is going out, due to the separation agreement only, they can go on. Then outgoing balance, I think that these are the major common observations that we are giving. Otherwise, if company give all the document as an exchange, we are giving approval spontaneously. In a sense, it's not spontaneously, we are giving it within a week time. The only thing is that the regulation mentioned that it has to be given a joint approval. So exchange has to wait for other exchanges, and then only both the exchanges can simultaneously can grant approval. But the only thing is that companies are not giving a disclosure on timely disclosure announcement. That a couple of advisory we have issues. In last 1 year, we have been issuing around 40 plus advisories.
Okay, Lokesh, just tell me, you are absolutely right that there is one confusion in the mind of everybody that they confuse with the relative mean the PSC, the group of relative, those who are the part of the promoter.
Okay. Yeah.
So you cannot say that one promoter has sold, so you are removing him, other promoter are still holding.
Yeah.
Okay. So that point is very clear. Second is you have given a very interesting point that even if you have a nil shareholding of that person, but you are coming into that category. So along with all other people, like my name is in promoter category, and my relatives are there. Okay.
Yes.
So I'm thinking that if I'm selling my share, I'm out of the promoter, so other is also out. So that
Yes.
is not.
Yeah.
But tell me how you are facing this type of problem which Anjali has discussed, that shareholding pattern, the marriage has taken place, the daughter has gone to another house.
So, if you see in IPO, whenever a company comes for IPO, there are multiple names of promoter and promoter group. Whereas shareholding pattern, when they file at the time of listing on the exchange, they don't give all the names. So what, for the ease of companies, what we have done is that whenever they file a first shareholding pattern to the exchange, that would be the base, and every quarter we will be monitoring that. So I'm not checking, as of now, I'm not checking from the DRHP names. Because DRHP, there would be multiple family members. So the example that you are talking about, the daughter got married, we are not going in that detail. That company and company secretary has a responsibility to maintain all this record. As an exchange, I am only monitoring for promoter and promoter group, which company is filing in shareholding pattern. So the first shareholding pattern that's filed become a base for us, and then every quarter we change. Okay, previous quarter there were 10 names. We have to make sure that it should be a 10 names. If less, then the approval has been taken from us, or whether some death or merger has happened.
Okay, sometime what is happening, you because SEBI is saying that stock exchanges are responsible for reclassification.
Yes.
And they are authorized and they have all power. But sometime what is happening, your hands are tight. And when you are going to the SEBI, they are saying this is not in our domain, you talk to stock exchange.
Yes.
So what is the solution available for everybody?
No, I think wherever it's required, we are helping in a sense jointly. We also offline, we are meeting once in a month. We are meeting with SEBI. We are discussing all the couple of cases, and wherever there are concerns are there, we are taking to SEBI and we are getting clear. Now the thing is that we are not holding the cases in the sense. So family settlement is there. If company give me a proper documentation, we are clearing the approval. In the sense now we are not holding any things.
Okay. Anjali, you have any point which you think in NSE this?
Yeah, I like Lokesh said that the first shareholding pattern, they do not consider the names given in the offer documents, but the first SHP is the base. But what to do in case of old companies? This can be this is a very good solution for the new companies which are getting listed.
The first the SHP I'm talking about is become a base for that previous quarter. So assuming a company got listed in 2000, I'm just giving an
Right.
example, March 2020, company got listed. So the first shareholding pattern will be filed on 31st March 2020.
Right.
Every quarter they will be filing. So previous quarter become my base. The thing is the first shareholding pattern, I will see all the names are there on that, and then every quarter we are monitoring.
Okay.
So for as on today, I'm sitting on 18th August. My base would be 30th June, because last shareholding pattern I have 30th June. Every quarter I'm doing a monitoring.
Okay.
So maybe it can happen that at the time of listing, there would be name of 10 promoter group. Over a period of time, company have taken approval from us, or over a period of time, some merger, demergers has happened. But as on the previous quarter shareholding pattern and current shareholding pattern, we only match.
Okay. So I think let's move forward. We have received so many questions. So I will cover this question. First, I'll request Ravi, some legal point you are having. On the basis of this, you can give your thought on this.
Thank you so much, sir. And good evening, everyone who's here. You would like to put a specific question, sir, or I need to summarize first whatever has been discussed?
Ravi, we want, because you are handling on the legal aspects of this reclassification. So like I have asked Lokesh, so he has given the crux of the things, what types of cases they are receiving and what they want to give advice. So in your opinion, the legal aspects, you are receiving cases, some are very procedural, some are very simple, some are legal. It's required legal interpretation, and interpretation has a problem. Okay.
Yes.
Because there is a deadlock somewhere. So what is the solution? So this, I just want your views on this.
Yes. So see, the controversy, as also pointed out by Lokesh sir, Anjali ma'am, and the speakers who have spoken before me, is that changes and unilateral changes into the shareholding pattern by bypassing the laws which govern and which must govern the shareholding pattern and the disclosures contained under it is the first problem. If you see the concerns on inaccuracy of shareholding pattern, particularly with respect to who are promoters and who are shown in public category, can be traced back to year 2006, when some changes were introduced in listing agreement and a circular was issued so that the disclosures in shareholding pattern can be accurately made. One of the objection or one of the issues that arose out of this non-standard practice, or I may say the arbitrary practice of corporates changing their shareholding patterns without any uniform yardstick, was that some of them were able to misutilize it for the purposes of minimum public shareholding, and that was a rising concern. Others, in other cases, it was being used as a tool of oppression. As you would remember, there were large disputes between conglomerates in India, where one used to remove the name of the other from the promoter category by utilizing this arbitrary force of changing the shareholding pattern unilaterally. But the journey of law has covered the ills, if not all of them, most of them. And the law as it stands today, the sanctity of shareholding pattern is at better footing than earlier. But then also there are concerns. When direct listing happened in 2016, or around that period, and there was dissemination board and companies were given facility to enroll themselves on these stock exchanges by going through the direct listing route. And I say this with professional experience of dealing with cases that companies made filings with incorrect data, including name of people who were not the promoters of the company. And those people were enlisted. Difficulty only arose when the SOP circulars came and their accounts got frozen because they were appearing either as a promoter or promoter group. Even more funny is that these companies, and there is not only one, two, there are many companies like that, and there are many issues like that. I'm sure exchanges, their officials, as well as SEBI is already fraught with many such cases. So the difficulty arises that some company shows someone who has no relation or connection with the company as its promoter. After some time, company incurs some non-compliances, and the consequence of that non-compliance comes to that person. Now, the difficulty is that the person automatically, because the name is coming in shareholding pattern, the person is automatically assumed to be governed by the provisions of 31 capital A, that is for reclassification. I feel that here the law could be a little bit tweaked, and rather it would require proper enforcement of law. If I assume, no, there are two things. One is that if there is any confusion in law, that confusion must be cleared to remove any ambiguity. But I feel that the law is not unclear. 31A only talks about reclassification of promoters who are promoters in law and as per the legal definition, not those persons who were shown by a company or a person acting on behalf of company in a fraudulent manner or by filing misleading disclosures, because misleading and fraudulent disclosures in itself hold no sanctity. So therefore, if tomorrow my name or anybody else's name is put up by a company fraudulently as its promoter, law will not expect me to run from pillar to post to get that correction made. That's number one. But unfortunately, the situation appears to be like that, at least in the law and the practice that is being adopted currently. That's number one. Number two is, Lokesh sir told that in fit cases where wherever there is a family settlement or it appears that there has been arrangement of detachment from promoter or promoter group, that has been given effect to, which is true also. So the main concern, if I may round up what I had said, what I have spoken so far, is that when the genesis of an action is into fraud, and the action is of showing someone as promoter or promoter group of a listed company, should that person be tasked with this onerous responsibility of running from pillar to post to get that correction done? Or should there be an adjudicatory mechanism? It could be a brief mechanism, given that such complaints are arising in number of cases currently, that the same needs to be verified, the legal basis of classifying that person as promoter, first time when that person was classified as promoter, whether there was any change in or control in the management of the company. All these facts should be considered. The SOP could be developed by the exchanges. That would reduce a lot of judicial work, as well as that will also help in better enforcement of the regulations. Because if we continue to allow these companies or these unscrupulous persons to continue filing and perpetuating these misleading disclosures, the fraudulent disclosures, it, I think, inherently mars the objective that we seek to achieve in the securities market, which is fair and transparent disclosure. So it will save two things. One, it will save innocent persons from unnecessary hassle. One. And second is, it will also ensure that the stream of information is not misleading in the securities market. So those are the two things, sir. And third is that, of course, it can't be used as tool of operation as it was being used earlier. Now, this particular aspect of the difficulty has been curbed down by the exchanges as well as SEBI. As I said, that sanctity of shareholding patterns is better as it used to be 10 years ago, 20 years ago. But still, I think to this little issue, which has serious ramifications for individuals and entities whose name are wrongly shown as promoter, it is something could be done for them. That's all from my side.
Ravi, just tell me, suppose somebody is doing wrongful act and putting the name of somebody or not removing the name.
Yes.
What is the hassle in this to remove his name? Where the law is creating problem.
Yes, there is a confusion in law. There seems to be a perception of confusion in law, because 31A does not say that only a promoter who is a promoter or a promoter group person by the legal definition, he can only seek reclassification. The law, unfortunately, is applied in this sense, that whosoever is reported as a promoter in shareholding pattern or any other document from where the yardstick can be chosen, he would be considered to be the promoter, and then the onus is on that person to apply through the prescribed route for reclassification.
Okay.
Now, I'm telling you, I've seen cases where people who were promoters 25 years ago, 30 years ago, and then there was subsequently a change in control in the management. Thereafter, company changed hands multiple times. It was acquired and divested by a number of entities and corporate groups. They also face this difficulty that the person was still shown in promoter group, and randomly. There was no uniformity. Some shareholding pattern showed him as promoter, some did not. So, and ultimately, he had to suffer because the company ran into non-compliances, and then he was frozen, and other consequences also followed. Now, this is just but one example. The issue is deep-rooted. The issue is one of perceived confusion under law. To my mind, there is no confusion. And I think one only needs to apply mind whether the disclosure of a person as promoter or promoter group was made correctly at the first instance or not. If this question is satisfied, I think everything will fall in place.
Okay. But Ravi, that is okay. But what is the way you are narrating is a very simple open and shut case. Then what is the problem to the stock exchange?
The problem to stock exchanges are multifold. One is the problem of perception. Is that how the law should be applied under regulation 31A?
No, but point is somebody's name is there in promoter.
Yes.
How can I remove unless I have some solid proof by saying some third party or somebody who is a promoter that I'm not the promoter?
Yes.
He has to give proof. So the question is, stock exchange is the authority to verify all these proof and do this.
Not all the proofs, and certainly that kind of detailed trial and adjudication can't be done by stock exchanges, but there are few indicative factors. I can only make few suggestions. Let's suppose I say that my name is fraudulently included in the promoter or promoter group. One thing that I can show is that the point when my name was included for the first instance, I did not share any relation of promoter. I did not fall into any category, any clause of definition of ICDR. And that is sufficient. To that, I think stock exchanges must apply their mind.
Okay, now let me ask Lokesh. Lokesh, the problem with Ravi is mentioning that somebody has sold the shares long back. Okay. Yeah. And the new promoter, a new purchaser has not transferred the shares. And the person is still showing as if, because till the time shares are not transferred, your name is reflecting there. And they have intentionally not removed the name of the promoter also, those who were the earlier promoter, and showing them as a promoter. So what is the solution? Now this person, earlier you are not having any chance, if I'm selling shares, that you can get information until some action is taking place. So the company got suspended. They got notice from the stock exchange that your account is freeze. Then they realized they saw everything. So the question is, if the company is showing wrongly promoter to that person, what is the solution to that person to come to the stock exchange and ask?
I think that BSc would better to answer because we have not got such type of cases. Only 2,000 companies are listed and mostly they are big companies. These type of cases we have not seen it. The only cases that we have seen that in one of the cases it tell that I was not aware of that I have been included in the promoter. Then we have told them that go and check the offer document when the company came with the IPO. So again, the company came in 1965 or 70, or I don't remember exact time. So we have mentioned that if your name was there in your shareholding pattern, every quarter the company, whenever they were filing the shareholding pattern, your name was showing, then you would be part of promoter group.
Okay, no, that is okay. But if the person is coming and telling that I sold entire shares, there's no share, no, I'm not on the board, I'm not coming, I'm not receiving any notice, things. So
there is a procedure. That is what we say, that the reclassification of procedure is there. You can apply. But now in your case, the company is suspended. So again, this is a very exceptional cases that we have now got it.
okay, okay. So stock exchange can do anything, or you have to go to SEBI or some other place?
We will be discussing because any exceptional stock exchange also has been given a power, but we will be discussing with our regulator and then we will be coming it.
Okay, okay.
On case to case basis, we will go. We will be going it.
Okay. So now what I'll do, the meeting is going on in SEBI and they will join. So till the time we have received few questions. So let me just see this and I will ask questions to Anjali and Lokesh and Ravi. They can give answer. Anjali, in Form MGT7, do we need to mention only those names which are coming in the financial statement as promoter, or can we add any other person in Form MGT7?
So MG,
Yeah.
again, the Companies Act definition is very clear as to who all can be the promoters of the company. So if anybody is falling within the ambit of controlling the company or advising the company, or as per whose instructions the company is accustomed to act, his or her name can be given in the MGT7.
What do you say, Lokesh?
So for us, the shareholding pattern become a base. So we are, as of now, we are not comparing with MGT7s.
Okay, okay. Nacharu, you have any point? Okay. Now, most important, if the shareholder of a private limited company is a body corporate and holds 99% shares in an Indian private limited company, so the director appointed on behalf of body corporate, then whether that particular director will be considered as promoter or not. Anjali.
But if somebody is holding 99% in the body corporate, which is my promoter, and the same person is a director on my board, on the listed entities board. So that means he's the person who's directing the company, who's advising the company for everything.
Okay.
So yeah.
You have any different view?
I think director is a different thing and the promoter are a different thing. Director cannot be the example that you have mentioned, that whether he hold or whether he is only a director.
No, I'm just reading. If a shareholder of a private limited company is a body corporate,
okay,
and holds 99%. Suppose company A and the company B is the shareholder of that company and holding 99% in a company. So the director appointed on behalf of body corporate, then whether that particular director will be considered a promoter or not. I think that will not be
that
considered.
will not be promoter.
Yeah. Because that may be a third party also.
Yes.
Maybe the promoter of the private company. Okay. So he will not be called as a promoter unless he's a promoter of the company, the company which is holding. Okay. Do we need to file minutes with the stock exchange? I don't think there is a need.
Yes.
Not required.
Yes,
Required, sir. Required.
When?
At the time of filing the application. Reclassification application.
Okay. So you have to file the minutes relating to that
Extract.
meeting.
We need to
That
extract
that
of the-
item. That item, yeah.
Okay. Now, in case of reclassification, whether the existing promoters need to make disclosure under Regulation 29(2) of SAST as the change of shareholding may reduce more than 2% from the last disclosure. Similarly, the existing promoter if holds more than 5%, then whether he or she has to make disclosure under Regulation 29(1) of SAST.
So if you see, I think there's a lot of confusion. SST, if you see March 7, 2022 circular, where SEBI has already issued a system-driven disclosure. Now
Yeah.
these disclosures are not required to file by promoter to company or exchanges, since if company, whenever they put detail in a designated depository are sharing the detail to exchanges. So once the person has been reclassified, their name should not be required to file in the designated depository.
Okay. Okay. So you have any other view, Anjali, Charu?
Same, sir.
Okay. Promoter holding nil shares want to be reclassified. Is there a need for shareholders' approval as required under clause 203(31)? Can we take exemption under the provision of clause 3?
Yes, sir. If the person seeking reclassification along with the related persons, they are holding less than 1%, and then no shareholders approval is required. The case is exempted for shareholders approval.
Okay. So I welcome Ashok for webinar. I have already introduced you. They were there in the SEBI meeting. Ashok, I welcome you. So
Thank you, sir.
Before going to the questions, we have given, Anjali has given a presentation on the journey of this reclassification and the law involved in this. Then Lokesh has given a point of view of the NSC point of view, what types of cases they are receiving. Then Ravi has discussed some legal aspects. Okay. So before I will take up further questions. Okay. We have just started questions. I want to take your view because BSc is, as compared to NSC, they are receiving more cases of reclassification because you have the old stock exchange and the old companies are there. So what is your message to the corporate world? What types of cases you are receiving and how you are perceiving this law? Because there are so many confusion in the mind, but as a regulator, you are very clear on certain aspects. So what message from your side? Over to you, Ashok.
Sure, sir. I think Lokesh would have covered the cases because case type of cases are same which we are receiving as a PSC. Because we both have mostly common listed companies. Issues that we are seeing is that first thing, since the disclosure requirement, which is the part of sub-regulation 8 of 31A, that we are seeing that many companies are missing out, and that that is the issue. We take time to process those applications. Second thing is that there is no clarity in the sometimes you've seen there is no clarity in the mind of the company when they apply 1% criteria, where is the shareholder approval is required and where it is exempted. And am I audible, no, sir?
Yes, you are audible. Carry on.
Yeah. Because over the time, as the regulation has evolved, a lot of clarity has been provided in the regulation itself, but still people have this misunderstanding of the regulation sometimes. That is what we have seen from our experience. And sometimes they assume that the reclassification is automatic till it is specifically clarified. Our understanding is that no matter whether it is pursuant to scheme, whether it is pursuant to IBC, whether it is pursuant to divorce or 0% promoter holding, reclassification is only possible on the compliance with the requirement of 31A, because whatever is the case, accordingly the documentation changes, but the exchange approval is still very much there before any company removes the name of the promoter, outgoing promoter from the list and reclassify them as a public. That is the broadly issue that we are seeing. And I'm sure that these the regulatory aspects has already been covered. So we go with the question answer session, and accordingly in the process, we'll clarify further what comes.
Okay, okay. Thank you, Ashok. Thank you very much. So now, if a person inadvertently comes in the promoter list because he was the person acting in concert with the promoter, and how he is no more than in the word and hold less than 1% holding in the company, whether he can be removed, whether we have to pass the board resolution, whether we have to pass the board resolution as well as the resolution, the shareholder meeting, whether a written request is necessary from the promoter if he is alive and hold less than 1% share, whether a letter can be written to the stock exchange that the person inadvertently comes into the promoter list and hold less than 1% holding in the companies without passing any board resolution. So he has given a multiple things. He is holding less than,
understand.
yeah. So yeah.
So the question, I think this is the precisely point which I have clarified in my brief for this thing, is that reclassification is possible only with the compliance of 31A. And then when it comes to the compliance, less than 1% shareholder approval is not required, but still board approval is required. And the request from the outgoing promoter is required. As far as accidentally coming in the list of the promoter or the promoter group is concerned, sir, earlier the discussion was with the company to whom they want to disclose in the promoter and promoter category. You see now, the requirement was those who are the signatory of the prospectus, and thereafter those who are included in the name as a promoter. Thereafter the regulation evolved and the promoter definition, group definition came into the picture. That being done, accidentally or otherwise, somebody appearing in the promoter group, our possible outcome is through 31A compliance, and basis on the shareholding and other criteria, the requirement of shareholder approval will be applicable, but board approval is must, their application to the company is must, because no such kind of exemption is provided in the regulations. So, sir, very in a very short form, whatever is not specifically exempted in the regulation, whatever scenario it may be, they have to comply with the regulation. That is our understanding.
Lokesh, you have, yeah.
Yeah, also just to add what Ashok has said, now the concept that he was back is not there because the company is filing a shareholding pattern from 2019. They are classifying in the sense, while filing the shareholding pattern, they are mentioning that this person is promoter or promoter group. Now company cannot say that this stage that I was not aware of that he was back, because for last 2 years or last 3 years he's been filing shareholding pattern in which he is mentioning that this person is either promoter or promoter group. There is no concept of PAC.
Okay, okay. Anjali, you have any view?
Agreed, sir. PAC is not needed to be given in the shareholding pattern. It is only the promoter and promoter group. If you are being shown continuously, you fall within that ambit, and 31A is to be complied with for reclassification.
Okay. In case due to ongoing dispute, if the existing shareholders resolution, if promoter votes against the reclassification of outgoing promoter, then what will be the remedy? Whether existing promoter are allowed to vote in shareholders meeting? If yes, then the existing promoter may hold majority shareholders may vote against resolution and make the reclassification difficult. Ashok, I think
all I can say is that when it comes to the exchange, we have to see compliance with the requirement of regulation. So that is something which is, I guess, when Lokesh can share his view, is out of our domain that we can say anything on that part. If somebody is not voting in favor, our regulation is not being passed, because what is we have been asked to do under regulation is to check compliance with the shareholder approval.
Okay.
And that is, I think it's a simple resolution, not a special resolution.
And I think this is an ordinary resolution, and again, the person who is outgoing and his relative will be holding only 10%, maximum 10%, because about 10% is not allowed. So remaining 90% would be voting in either in the favor or not favor. So this, I don't think this question is relevant.
Okay.
And the outgoing promoter is not allowed to vote.
Yes.
But like Lokesh is saying, this is ordinary resolution. It is not 3/4 majority, right? This is not SR.
Yes, yes. Okay, now one promoter is holding more than 50% shares and his immediate relative, who is his son, who is also designated promoter, holds nil shareholding. Can the son be reclassified as a promoter as he is not a shareholder nor he is on the board of the company? I think the answer is yes, he is a promoter because being a relative of this, whether he is holding shares or not. So there is no need to do anything. He is a promoter. You can. So now the question is, I'm not holding shares and I'm not the director. So how I will show in the shareholding pattern? Should I?
So no, sir, what must have happened is in the first shareholding pattern, whatever was filed after the LODR, his name was shown. Maybe he was holding shares prior to the nil holding today. So at any point of time, his holding was there in the company. But now he has transferred his shares and is holding nil shares. But what I understand is because he is holding nil shares, can he be reclassified in spite of being the son of the promoter?
No, Anjali, his question is not this.
Mhm.
The promoter, my son is there who is not holding shares, not in the board of the company.
Right.
And there is no need to show him as a promoter because if he's not holding shares, I'm not showing in the promoter because promoter list, we are not giving all the list of the promoter, those who are holding 0 share. Okay.
No, sir, I think that is, in my view, that is not correct because now with the change in regulation, entire promoter and entire promoters are to be shown irrespective of the fact that whether they are holding any shares or not. Even 0 holding, if you see shareholding pattern of many companies, there are so many entities shown under the promoter. They may not be shareholder. So if you count, say under promoter category, if you count shareholder, there may be 10. But if you see the first annexure of the shareholding pattern, the number of promoters may be more than 10. Why? Because many of them are not holding any share. Lokesh, you want to add on that point?
No. Go ahead, Abhishek. Yeah.
But Ashok, if you see the shareholding pattern of various companies for a sample testing, then they are not showing the list of everybody who they are. Yes, that was the law that all the people, those who are coming in the promoter definition, they should be shown whether they are holding shares or not. But in practical, if
Yes,
you take the shareholding pattern of various companies, they are not showing every list of the everybody. So
that's correct, sir. Not showing is a different thing. And like you said, law is something different. It shows that even if they're holding 0, they need to be shown as a promoter. So,
okay.
and for the reclassification purposes, regulation 3 says that the outgoing person along with the person related to them. So even that point in time, that will come into the picture, the holding of the father or the other family members.
So
who are relative as per Companies Act. Yeah.
Okay. So the question which has asked, it means there is no need to do anything because he is the son of the promoter and he's holding nil share. Even he's not a director, he's a promoter. There's no need to do anything. Okay. That's the correct answer.
Well, he will continue to be promoter. Yeah.
He'll be shown as
Included in
promoter group.
Okay.
So just to add it, his name might not be there in the shareholding pattern because he was nil holding, assuming his name was not there in the shareholding pattern. But informally, he like, in the sense there are many disclosure which is not required. That's what I said. As an exchange, we are taking base. But in case if we buy anything in future, his name will be shown because ultimately he was a part of promoter and promoter group. If he really want to do a reclassification, then he has to apply reclassification. Entire process of reclassification he has to apply.
Lokesh, the law is very clear that anybody who is like this, but I'm just showing the list of promoter. So his name is not showing in the list of promoter. So is there any compulsion? Because that is a confusion and I think it's the right time to clarify. If a promoter, I'm just talking about the shareholding pattern which we are submitting to the stock exchange.
Yeah.
My son is not holding shares and he is my son, so he's a promoter and he's not on the board also. So if he's not holding, should I show him in the shareholding pattern his name or not?
Sir, shareholding pattern name as of now, it's not required, because if you see the consultation paper, there were a lot of, when SEBI issue initially in consultation paper, came out that all the names should be there. Then a lot of corporates has gone there and they said that we do not have a history of entire 3 generation has happened, 4 generation has happened. So that's why exchanges have, and along with SEBI have discussed that we will take a shareholding pattern as a base, but as a company secretary, they need to maintain the entire promoter group, PAN and all these details, because ultimately, in case if that person buy the share, he automatically become part of promoter group.
Loki, Ashok, what is your view? Because practically I have told you that but you are right that company secretary should maintain. But I think there is a confusion in the mind of industry that they are showing the shareholding pattern and then they are thinking this is the promoter group. But where they should keep that record? In which format?
That they have to maintain. Otherwise, we as an exchange or as a regulator, so we were ready to put it, but there are many companies that do not have the data.
Okay.
The example that you have quoted, daughter has gone to married and.
Got it. Anjali, you have seen any cases like this?
Sir, that's a very common thing, that if somebody who's not holding the shares in the company, their names are not shown in the shareholder promoter group list, even though he's a son or a daughter or wife.
Where the company secretary is keeping that list?
Maybe in some Excel or whatever, but shareholding pattern, his name is not there. So as and when this person acquires the shares, say tomorrow he acquires one share, even a single share from the exchange, his name would be coming in the shareholding pattern with a single share.
Okay. So I think Ashok and Lokesh, this is the one clarification stock exchange must, or you are right that corporate has opposed this. But simultaneously, we should tell corporate also where they should keep this list ready with them in a official basis, not the Excel.
Of course.
Like SDD. Okay. Okay. Now, if a relative of promoter is currently not holding any share but wish to acquire some shares but as a public shareholder, so whether the request of reclassification can be made before acquiring shares? I think he is mentioning if the relative of promoter. So relative of the promoter is 2 types. Relative is a very vague term. Either a relative as per the Companies Act, which is a part of the promoter. So you treat that this is a part of the promoter if the relative of promoter is currently not holding any shares but wish to acquire some shares, but as a public shareholder, I think that is not allowed. So whether the request of reclassification can be made before acquiring shares. So he has to follow 31, then he can make this request. And if he is acquiring, then he has to show in the shareholding pattern as a promoter. Ashok is right?
That's correct, sir. Because
Okay.
reclassification are there. In one category, you want to change the category, right?
Okay. Now, when the provision is not linked to clause 2, is a approval of the shareholder not necessary, hence this query.
No, I didn't get it, sir. What?
Mr. Chandra, you please explain this properly. The query is not complete. Okay. What are the advantages of being promoter in the company apart from control? You are the boss, you are managing company, you are enjoying all.
Everybody, yeah.
सारी लड़ाई control की है.
So he is saying what are the other than control? The control की तो लड़ाई है, everything is on kursi bhai. Okay. We have checked the SEBI provision, but nowhere it requires to mention the name of promoter and shareholding pattern with nil shareholding. Can you please help with any circular issued in this regard? So my query has come to Lokesh.
So there is no circular. That is what I'm saying, that the consultation paper came. We are not saying that nil circular, but we have issued FAQ, multiple FAQ, in which we have mentioned, okay, once your name is there in shareholding pattern, and if he sold the shares, then still his name should be there. If you can check in the master circular that exchanges have issued, it will be there.
Okay. Okay. So Ashok, you want to say anything?
No, sir. No, sir. Sorry, I'm traveling.
I know. I could. Okay. We are grateful that despite of all these problems, you are participating. Thank you very much. Okay. Can you please clarify on the point where the company has applied for waiver of penalty? Can a company simultaneously apply for reclassification or wait for completion of penalty case?
So waiver, there is a separate module where company can apply. Until unless waiver decision is there, we will not be able to reclassify.
Okay. Okay. So
Agree. Yeah.
So you without waiver, without paying the penalty or waiver, the reclassification will not take place. So you apply, simultaneously process the reclassification thing. Once waiver is there, reclassification will take place, or you pay the penalty in reclassification. Okay. I was classified as a promoter group of a company which has been referred to resolution professional. The framework of resolution professional recommended reclassification. However, company has not reclassified me despite numerous requests, and my demat account has been frozen because of a non-submission of under 31(4) SEBI SST to exchange. Company is writing to me, but however, I do not want to make any declaration as I wish to be reclassified. Which company is not doing? How do I proceed?
That is a specific case which need to be studied before answer, because there may be so many other facts also.
And also, just to add it, a company which is in the IBC, exchanges are not freezing the promoter freezing. We are not taking any actions. As
That
I
we
am
have done before, yeah.
Okay, so that is clear. The demat account of independent director frozen by BSC White circular of SEBI for non-payment of listing fees by the company. SEBI said director does not have single share in the company. Complain on score and correspondence with BSC and SEBI official. What is the remedy? So he is, Ashok, this question is to you. Demat account freeze because he is a independent director. So is it any remedy is there to him?
So for non-payment of ALF, there is a separate guidance from SEBI, because other freezing happens pursuant to SOP circular. Non-payment of ALF is a separate circular, so that would have been done by following that circular only. So they have to approach exchange, and then the process will be followed for the unfreezing.
But
Because
independent,
we don't have discussion.
Yes, exactly.
Because independent directors, promoter holding, that's what I'm wondering, because fact
Yeah.
needs to be checked.
It's not there. Actually, independent director will never freeze it.
Right. So if the statement is correct that independent director's PAN is frozen, that's why I said that is the matter of fact that need to be checked, because promoter, I understand, independent director का PAN कैसे freeze करेंगे इस
अशोक ये भी तो हो सकता है कि मैं पहले प्रमोटर था, उसके बाद मैंने उसको कूलिंग पीरियड दिया, फिर मैं इंडिपेंडेंट बन गया. My name is continuing. So okay, so Sumit, you can request to stock exchange if you are a independent director. Account cannot be freezed, but there must be something else. So you can request a stock exchange and they will help you. Still not understood. Yeah. Still not understood the requirement of shareholders resolution, as the shareholders are not actually aware about the intent of reclassification, and this can be misused by existing promoter to halt the reclassification of outgoing promoter. Now this is a legal jurisprudence issue. So Ashok and Lokesh.
So the purpose why shareholder approval is required being there are some shareholders who have put money because that promoter name was there. If he is outgoing, shareholders should be aware of that. He holds this much percentage and he is outgoing. That was the reason.
Okay. So this has Ashok, your view. So I think what Lokesh is saying, it has come when the takeover law has come. The takeover law, that time, the question is, if the control is changing from the existing promoter to other promoter, then there was a question that why open offer? Okay. So that logic was given that I am the shareholder and I am having a faith in Ashok, and now you are taking control of the company. So I don't want to continue. So that's why they have done. So that's why shareholders, and shareholder is not which group. that is a number. So this is a sanctity that whatever you are doing, you ask shareholders. Okay. If a company is unwilling to cooperate, can a person wrongly mentioned as promoter group approach SEBI and exchange on their own?
If company is not cooperating in the sense that they have officially written to the company that I want to be reclassified from promoter to public and I am in compliance, well, they are in compliance with the requirement of 81(1)(a). But the thing is that the company is not filing that application because timeline has been prescribed under regulation itself. That when they receive the request from the outgoing promoter, within what time they have to make disclosure, then when board meeting should happen, when shareholder approval meeting should be taken, and when it should be filed with the exchange. They're not filing, following the LODR regulation, not complying it, they can approach SEBI, and then definitely then we can take up the matter.
In addition, as per the SOP circular, there is a per day penalty of 5,000 rupees if there is any delay in filing the application. So the promoter can, the non-cooperating company and the promoters can be told for that as well. अगर मैंने request किया है, तो you have to follow the entire procedure.
Anjali, if a company is unwilling to cooperate, a person wrongly mentioned the promoter, so you can go and show it because he's not the promoter. Stock exchange will satisfied and do it.
I agree, sir. But what I'm saying is, if the person really does not belong to the promoter or promoter group, so and he has filed the reclassification request, company has to follow a particular procedure. Correct. Which is given.
So also we cannot decide on the, we cannot judiciary body that we can decide who is right, who is wrong, and then basis on the submission that I am not the promoter and the company is wrongfully showing me promoter, you reclassify because they are not.
So you have to follow the 31.
Reclassify. Answer is no, sir. Okay. Yeah, answer is no.
Yeah. I have a doubt if any group acquire shares more than 25% of a company, but in the facts, acquire do not receive any more than 25% shares from the promoter of target company as per the share purchase agreement. Now, what is the status of acquirer? In this case, will acquirer to be considered promoter or not?
Question is not clear, sir.
Actually, maybe nahi samjha nahi.
Maybe question is not clear.
Garima, please clarify this again. We will give answer. A person who is coming into the promoter list dies and his shareholding is going to a person not related to the promoter company. Whether the person will come into the promoter list. Answer is
yes.
Answer is given in regulation itself,
yeah.
sir. It
yeah.
will.
Yeah.
Inheritor automatically steps into the shoes of the promoter or promoter.
And Ashok, suppose that the person who is getting share, it is his girlfriend.
Anything, sir. Anything. Ultimately, whoever getting the shares will be classified as promoter.
Okay.
Okay.
A person who is coming into if we find that a relative has just purchased shares and have fallen in definition of promoter, then simply adding their name in shareholding pattern is sufficient. I think that's sufficient.
Yes.
Yeah. If a company promoter holding is zero, shall we have to give the name of the promoter shareholding pattern with zero holding that we have explained? But if company did not show the name of the promoter having zero holding till date, then what to do?
So is the company falling within the ambit of professionally managed company? Because then the provisions are separate, but that will have to be checked.
Okay. No, I think Anjali answer is very clear. If the company is promoter holding zero, still have not given name of the promoter. So what happened? He's a promoter. You are holding which location because as per the that industry representation, there's a part of the law. If the company did not show the name of promoter having zero holding till then what to do? So it means you should have keep this record with you. Now you're not keeping record. There is a mistake of the company.
Right.
Exec of the board extract of the board meeting is sufficient or minutes in reclassification application?
The law says minutes.
Okay, not the extract.
But Ashok, in matlab, many a times minutes are not signed immediately.
That we understand. Here we're
Yeah.
talking about law.
No, Anjali, but if they are asking minutes, then you have to give minutes. Okay. Only thing is, I should give the complete minutes or I should give that minutes of that item. Ashok, what you have to do? Because there's
Minutes of the item you require, but the point is, like Anjali is correctly saying, it is not possible because I think within 24 hours, right, Anjali, they have
Yeah,
to give the minutes of the
Application.
board meeting when it is approved wherein the board has approved the reclassification. So they get outcome of the board meeting. That is also we can consider. I mean, because that is there may be difficulty in getting entire minutes approved within that much time and submitting to us. So we consider, but law says that it should be minutes.
So Anjali, when you have to do reclassification, you can get it signed and it is in the big company. These companies, they can manage this.
So maybe we can, what the companies are doing, they are submitting the certified true copies of the resolution.
Yeah.
Yeah.
But are you accepting Ashok or Lokesh certified to copy of the resolution in place of minutes?
I need to check, but I think we are accepting. Ashok, you have a different view.
Well, submitting to us is different thing. This is the requirement of 8.1 sub-regulation 8 that they have to give outcome to the as an announcement material even kind of thing.
Okay. Sir, if the private limited company, one of the subscriber is not ready to bring in the subscription amount, what is the remedy? How do I think this is not the question, Tejashwini, for today's webinar. You can ask separately. What happened if the company received request for reclassification, but company failed to call shareholders meeting? Now, this is Ashok. This is the one problem which suppose I have requested and the company is not calling shareholders meeting and they are avoiding this. What is the solution for this?
Then I think they can approach SEBI because that becomes again a matter of not following the LODR regulation.
But problem is there. SEBI is saying that reclassification go to stock exchange. We don't interfere.
Okay.
And when
Okay.
They can apply
Okay,
to the
sir,
exchanges and exchanges can also discuss with SEBI. Ashok,
Yes,
we are
yes.
already discussing a lot of things with SEBI. So
Correct. So
anyway,
we will take up with the SEBI.
Yeah, we will be taking them with SEBI.
Okay.
It has to be jointly. In the sense, we cannot, nor BSE can take a call, nor NSE can take it. It has to go jointly and discuss with SEBI.
Okay. How to remove the person who is coming into promoter and is no more in the word and there is no one claimant of his shares?
That is a question. So we have issued recently an FAQ. I think recent in the sense 3-4 months back, where we have mentioned that until unless shares are got transferred, the person's name should not be there. Although he is dead, you can put a remark.
Yeah, the asterisk will give the exact situation. We clarify.
Okay. A minor son of promoter holding nil shares, when company should declare him a promoter, in none of the earlier documents submitted his name has been declared as he was minor.
These things will change over a period of time. There will be a born of daughter, son. The things will add. That company secretary had to maintain.
I think this is a procedural part you have to, because stock exchange is asking to true and clear picture. So as soon as he is becoming major, you have to show him as a, nil holding is not a issue, or you have to keep record. But I think Ashok and Lokesh, so many people are asking this question that if person is holding nil shares and how to show. I think stock exchange or SEBI should come out some solution for them.
Sure, we'll discuss with SEBI.
Yeah.
Sure.
Promoter fathers passed away, demat account are freezed due to non-payment of annual listing fees. Whether son who is yet to get shares by transmission will enter public or promoter.
Promoter only. There's no question.
So yes, he is a promoter. Yes.
Promoter only. Law says this.
Yeah. A private, because another thing is you are getting something in transmission or will in your name or some asset is going to you. So the asset is going, so all liabilities will also go with you. A private limited company which is holding company and has created a wholly owned subsidiary company, and one of the director of the holding company is the subscriber to the chartered document, can also be treated as a promoter of the subsidiary company. What is the criteria in such case? Shareholding of the holding company is the base. Anybody have understood this question?
Question is needed to be
Okay,
further
a private company which is the holding company and has created a wholly owned subsidiary company, and one of the director of the holding company is the subscriber of the chartered document, can also be treated as promoter of the subsidiary company. What is the criteria in such case? Shareholding of the holding company is the base.
I think it is talking about a wholly owned subsidiary, so that would be a unlisted company. Then the provisions of Companies Act would govern as to who is the promoter.
Mr. Venkataman, you send this query to us with detail. We will reply to you because it has multiple combination and something is missing in your query. The two queries are connected. The provision is connected to clause 3 of 31A(3). Clause 2 requires approval of the shareholder. How can you say that there is no need for approval of the shareholders when the percentage holding is less than 1%?
It is given in the regulations itself, when the outgoing promoter, along with persons directly or indirectly controlling him, if it is less than 1%, shareholders' approval is not required.
Okay. If a company is under IBC and demat is frozen, but accounts are not be frozen as stated by Mr. Singh, how to remove freeze? Is there any circular to this effect? Ashok. How the IBC, the company has gone, before going to IBC, account is freeze, suppose, and then it has gone to IBC. Order is not passed because if the order...
Sorry,
Yeah.
just like I said, I was telling. Sir, IBC accounts are not frozen, but this is the case when the account would have been frozen before company went into IBC.
Yeah.
Because normally we have seen company become non-compliant in the issues, and therefore they go to IBC. The promoter demat account is frozen. My understanding is that only because company is in IBC, admitted in IBC, the promoter account are not automatically unfreezed.
Okay.
So
Okay.
that would have been the case.
So Ashok, suppose account freeze one, then they have gone to IBC. Now IBC matter is going in IBC. I should ask to the court NCLT that please instruct that they should defreeze my account.
I mean, you can make such request. That part we have to check with legal whether what should be our stand in that case.
Ashok, Lokesh, you have any view on this?
No, I agree. We need to go to legal only. This is a separate case.
Okay. My query, suppose existing promoter holding 60% and outgoing promoter is holding 5%. And there is a dispute, then the existing promoter are holding 60%, they vote against the reclassification and the shareholder resolution. Then outgoing promoter cannot be reclassified. So existing promoter shall also not allowed to vote in the shareholders resolution. What is the solution for this?
This is a separate case.
So that we discussed earlier now. We will, for us exchanges, we need to have approval. Now the issues with the approval, and that is something which we cannot comment, I guess, right?
Anjali, have you seen this type of cases?
Honestly, no. But regulation 31A presently says that you have to obtain a shareholder's approval and the continuing promoters are allowed to vote. So there has to be a change in law for any such situation.
In such cases, if it come, they can directly forward an application to exchange that we want to reclassify. The existing promoter are against us, and that's why we are not able to pass the resolution. we can separate it daily. Case to case basis, we will go to SEBI and we'll get the approval. In the sense, we'll see case to case basis.
So Ashok, I think what Lokesh is saying that this type of cases will come, then use case to case you will deal.
Yeah. Normally, we jointly represent to SEBI. This is the matter, and then with their guidance, we deal with the case.
So Pooja, you can go, Pooja Kulkarni, you can go to the stock exchange, request them and tell the exact thing. And then the stock exchange in consultation with SEBI will take a call. Can certified true copy of extract of minutes can be given? Now this is a procedural point. Law is mentioned that yes, you can give certified true copy. Sure. It will be the context of private company, and there is a few more related questions too, which I will share. Okay, you can send it, Mr. Venkataman. Okay. A person is promoter list, hold nil shares and expired. How to remove his name?
No approval is required. Only thing is that the share got transmission to another person. That name will come.
But there's no.
If it's only zero, then it will be removed.
Oh, nil. Okay. Then the automatically, if it got expired, automatically his name will be removed.
So now here's the question is that when I was promoter, I have given name of my other relatives, which is the company secretary's holding. So once I died and I am not holding shares, so you are removing my name from the promoter. So it means my all other relative will also out from the promoter list.
Sir, application will have to be made. For example, the promoter shares are inherited by the son, and earlier.
So Anjali, here there's no share. I'm the promoter, not holding shares. So when
Not holding shares. Okay.
I'm a promoter, so my family member, my relatives are promoter. Now
Right.
I died. Then when I died and I am not holding any share, so how can you remove other people also?
We cannot remove without approval. We cannot remove only the person who has died. His name will be removed.
Yes.
But remove the other people will be the promoter. So that's why this type of cases will create a confusion in the stock exchange also, because there's no list available. So you have to.
Sir, to be very frank, as an exchange, we will not be able to maintain because we do not know how many person has gone.
Yes.
What has happened, born, marriages, and that record as a company secretary has to only maintain.
Okay. Okay. So I think we have given all answers. So few questions which are not clear, please send it to us. We will give answer to you separately. So friends, now it's time to close our session because it's about to 6 and 4 to 6 hour is a brand which we have created for every Friday. And this is our 141st webinar, which we are continuously doing since the last 3 years. So before closing this, I will request Lokesh and Ashok, please tell us the message to the corporate world related to this issue.
Messages are in case of any confusion, we both exchanges are very much open to guide whoever having any confusion. They can approach us. Many of the questions we already answered. And only that much I can say because otherwise, so law is there, everybody can read it. But still, in the processing, any issues that we are there to help you.
Okay. Lokesh?
Agree with Ashokji. In the sense, as an exchange, we will always there to help. In case company asking us to deviate from the law, company also have to understand that we do not have a power. There we have to go to the regulator, we have to discuss the case, we need a more detail. Otherwise, if companies following the law, we will be always there to cooperate.
Okay.
And in past, just to say, in past also, we have granted approval at 12 o'clock, morning 4 o'clock. In the sense, wherever company is required, we are always supported. Both NSE and BSE is supported. So we will always be there to give approval.
Okay, Charu, you want to say anything? Charu, any?
Sir, just want to say thanks to the exchanges for their guidance on the topic, and much clarification has been given by them on this topic because there are so many confusions going on. So thank you both of the.
Ravi?
I think I would like to add only this much. that the hassles that are there to get out of the remit of the promoter and promoter group, it is equally easy for a company to put my name, even the name of the officials of stock exchanges into the list of the promoter of a company. The situation might be a little different today, but just if someone opens the can of direct listings, you would find that these things were rampant back then. I do not know whether those safeguards are there still or not. If not there, the exchanges and regulator must work hard to build those safeguards, and that's it. Because the exit route is already guarded by procedure. Problem is the entry route is open, and that opens the floodgates of all the issues. So therefore, that needs to be controlled.
Okay. Anjali?
First of all, a big thanks to both Ashok and Lokesh for being a part of this webinar, wherein there appear to be lot many confusions in the minds of the corporates. And I totally agree with Lokesh. They have both the exchanges are ever open for any of the queries which come or any of the confusions which arise. They even, many a times they even tell ki, okay, we'll talk to SEBI and we'll try to resolve. As far as the topic is concerned, I think certain FAQs or certain Q&A should be given by the exchanges or by SEBI, mentioning the confusing points which have still evolved during this 2-hour discussion. If need be, we can give more suggestions to the exchanges so that a simplified and a streamlined law can be evolved. Thank
Ashok,
you.
so thank you, Anjali. Ashok and Lokesh, what we'll do, we have received queries on this webinar as well as queries in other webinar also. These questions, some questions are ticklish, some questions are confusion. So if there is a confusion, the stock exchange can clarify. So if stock exchange is a prerogative of stock exchange, then they can come out with FAQ on this. So it can be very clearly mentioned. So I think, thank you very much. Thank you, Ashok. Thank you, Lokesh. You are both very knowledgeable and you have dealt in so many years these things. So your knowledge has really enriched everybody, including me also, including everyone. So thank you all. Thanks and thank all participants. Dear friends, this journey of knowledge sharing will continue, and 4 to 6 on every Friday we are meeting and we will meet. So our next webinar is very interesting, and we are doing with SEBI, stock exchanges and depository. So all 3 agencies will participate. Freezing of pen of designated person under PIT regulation, that is the topic, and we will discuss. So you can register yourself, tell other friends also. On that basis we can move. Thank you very much.